Good afternoon, everyone. My name is Susan Frederick with the National Conference of State Legislatures in our Washington, D.C. office, and I would like to welcome everyone to today's Supreme Court Roundup Part 1. With us this afternoon, we have our very own Lisa Soronen, who is the Chief Counsel and Executive Director from our State and Local Legal Center. She files amicus briefs on behalf of NCSL at the Supreme Court, as well as on behalf of 6 other state and local government associations representing elected officials. And without further ado, I'm going to kick it over to Lisa.
Thank you so much, Susan. I am so pleased to be here giving this presentation. Although, on the other hand, I'm somewhat devastated at the reality that we're not all in person together in Indianapolis talking about the Supreme Court. It really was an extraordinary term, and I'd love to be with you in the same room, not virtual, real, telling you the story of it. So a couple of caveats before I start going through the material. The first one is that usually by the time I speak to NCSL, I've given a Supreme Court presentation a couple of times, and it's very smooth because I've worked out the kinks. And in this case, this will be the first time I've done this version of the presentation, so I hope it doesn't have too many rough moments. The second thing is that, Supreme Court and appellate types think of themselves as generalists and generally don't think that they need any sort of special expertise to talk about cases. And in the past, I've always felt that I had sufficient knowledge and understanding of cases to talk about them competently. But this term has a lot of really complicated cases where expertise would be helpful. And if you like the listening format and you really want to hear about these cases from actual experts in the subject matter, I encourage you to go on the American Constitution Society's website and listen to their webinar. They cover almost all the same cases I do, but with subject matter experts. And the third caveat is this. My dog had a massive seizure last night despite taking seizure medicine, and I just don't have the heart to kick her out of the room with me. And I really believe that she will behave, but an hour is a long time. And so I hope that she isn't a problem, but I can't say that she won't be. So now on to the presentation. So what I intend to talk about today are the biggest cases of the term for states. And then what happened to Chief Justice Roberts? He had some unusual votes this term, and I'm going to talk about some of them and maybe why. And finally, I'm going to conclude by talking about the president's tax return cases. So there'll be another presentation on August 4th, which will continue this conversation. And in that presentation, I intend to talk about some of the other important cases decided this term for states and give you a preview of some of the cases the court is going to hear next term. So as many of you probably know, the court was actually down 10 cases. And that's because they moved 10 cases from this term to next term because they didn't know what to do to deal with COVID-19. Ultimately, they ended up canceling their sitting in March and in April and having a May sitting. But that May sitting only accommodated 10 out of the 20 cases. You would never know that the Supreme Court was down 10 cases because there are so many amazing cases to talk about. And I think of all the years I've worked at the SLLC, this term, I think every single really big case impacted the states. It's usually the case that most of the big cases impact the states, but this term, I mean, the states have an impact front and center in all the cases. And the other, obviously big overview of the term is that the Chief Justice took a sharp turn left, as many of you know, in many of the cases, and we're going to examine that later on in the presentation. So I'm going to start with June Medical Services versus Rousseau. This is an abortion case. It was a 5-4 decision where the court struck down Louisiana's admitting privileges law. So 5 justices said that the law created a substantial obstacle to women obtaining abortions, and it was a plurality opinion joined by Chief Justice Roberts where he provided the 5th vote. That's kind of like the headline version of the case, and it sounds pretty simple, right? Well, I can assure you this case is anything but simple. So let me explain how and why. So as many of you know, Texas had an identical law, essentially, to Louisiana's, which was struck down a couple of years ago. And Justice Kennedy was on the court, and Justice Kavanaugh wasn't. So that was one of the differences. And basically, admitting privileges laws require doctors to be able to perform surgeries in hospitals. It's hard for abortion doctors to get these admitting privileges because often they don't do any surgeries at all because abortions don't generally require them. They don't require hospitalization. So in 1992, the Supreme Court decided the Casey case. The Casey case, it's kind of funny. It didn't come out when I was doing the practices by myself. And it has the language that I have here in different colors. And basically, the language, what came out of the Casey decision, there's only 3 justices that actually signed on to this language at the time. And there's a great deal of a disagreement over what this language means. But the short version of the long story in this case is that there's a disagreement between Justice Roberts and the liberals about the language in green. Hard to have color combinations. So 5 justices, including the Chief Justice, agreed that when you're looking at abortion regulations, you should consider whether or not there's a substantial obstacle. The 5 justices found a substantial obstacle. But 4 justices, not including Justice Roberts, did a balancing test, saying, abortion restrictions shouldn't be allowed if they provide no benefit for women's health. And so what we're going to do is we're going to weigh the benefits and the downsides. That's what 4 justices agreed to, but not Justice Roberts. But that language in green, the balancing test, Kennedy had agreed to that. But Roberts didn't agree to it then, doesn't agree to it now. So like I said, 5 justices said the language in red, substantial obstacle, that's the lay of the land. We'll agree with that. And why was there a substantial obstacle in this case? Well, as it turns out, making admitting privileges the law of the land in Louisiana meant that only one abortion clinic could continue to be open with one doctor, and he probably couldn't see more than 30% of the abortion patients in the state. So the Chief Justice basically said, substantial obstacle is the test. I don't like that test, but it is a test, and this case is basically the same thing as the Texas case. In the Texas case, the Texas lost, so Louisiana has to lose as well because of stare decisis, because this is how we have interpreted that case. But he rejected the idea of having the balancing test, where you look at what benefits a law provide to women. And he basically said he didn't agree with that test and that he wouldn't apply it. So on one hand, he said, I'm going to use stare decisis to do what we did in the Louisiana law, in the Texas case, but only for part of it, only for the ultimate holding. For the reasoning on the balancing test, I'm out. I'm not interested in that part of the test. So the bottom line here is that one way of looking at this case is that Chief Justice Roberts saved abortion, because after all, he could have, said, I stand by my dissenting opinion in full in Whole Woman's Health, and so this law has to fall as well because it's, I don't agree with that law. But he didn't. He said, because the laws are substantially similar, I'm going to stick with precedent and just leave things where they are. Now, with that said, the left's enthusiasm for Justice Roberts' decision was very, very muted. Linda Greenhouse basically said, the Chief Justice was stuck between a rock and a hard place. Like, the Fifth Circuit basically ignored the court's ruling in Whole Woman's Health, and he couldn't really tolerate that. But he still said Whole Woman's Health was wrongly decided. He didn't join any of Justice Breyer's opinions, even the parts that he agreed with, and he effectively voted to kill that balancing test that I talked about. So here's the bottom line for states. There are a lot of abortion laws that may not cause a substantial obstacle for women to receive abortions, but also that provide arguably no health benefits for women. Just 2 examples are ultrasound laws, not allowing chemical abortions to be done over telemedicine, And so it may be that those laws are now constitutional because the balancing test has been essentially gotten rid of. Some conservatives have pointed to the fact that Roberts said in this decision that he wasn't going to consider overturning Casey because no one asked the court to, and that he might be sort of suggesting that people go ahead and do this. I think that's maybe an overreading of the opinion, but it's kind of interesting. Another really interesting thing about this decision is that in Whole Women's Health, the Chief Justice dissented, but he didn't dissent because he didn't like the balancing test. He didn't talk about the balancing test at all. It was Justice Thomas who said, I'm dissenting because I don't like this balancing test. And so that was kind of an interesting sleight of hand for the Chief Justice. So Tom Goldstein, a notorious Supreme Court advocate, has said, this case is probably more of a victory for the pro-life, pro-abortion restriction side than it is for liberals. But on the other hand, the more liberal position was preserved, the more liberal outcome was preserved, even if the test changed to be a more conservative view of the law that the Chief Justice prefers. So the next case where the Chief Justice's vote again made a significant difference is the DACA case. So this case is again a little bit on the complicated side. So but the ultimate decision is a 5-4 case written by the Chief Justice where the court said that the Trump administration's decision to wind down DACA violated the Administrative Procedures Act. So this is more really in an administrative case than an immigration case. And if this case reminds you of the census case from last year, you're exactly going in the right direction. And if you get kind of lost in this opinion, I think that is understandable. It's very, very, I don't know if technical is the right word. It's very complicated and very nuanced. So, but the story of DACA is not. So President Obama came up with DACA. It was a program that allowed children who are undocumented and in this country for a long time to not be deported for a certain amount of time and to receive work authorization. So President Trump wanted to rescind the program. And the basis for which he had his Attorney General do it was saying that it was illegal, that President Obama did not have the authority to come up with the DACA program. So litigation was happening over this case, and the D.C. Circuit basically said, Homeland Security, you've only said you wanted to get rid of this program because it was illegal. Are there any other reasons you might want to have gotten rid of it? And Secretary Nielsen wrote a memo giving other reasons to get rid of DACA, like it, encourages people to not follow the law and that kind of thing. But ultimately, like I said, the court said that the DACA program could be rescinded, but it wasn't. The Trump administration didn't do it properly, and it didn't do it properly because it didn't look at important aspects of the problem, and it didn't consider the reliance interest of those who received the DACA program. And interestingly, the court offered no conclusion over whether the program was, in fact, illegal. The court would not consider the Nielsen memo, saying, it was written after the fact, and it didn't go through the procedures that the Administrative Procedures Act requires. So now getting more into the nitty-gritty, what the court said was basically when the DACA program was rescinded, the only thing that the Department of Homeland Security looked at was the fact that undocumented children and now young adults, couldn't, that the INA didn't give them authority to work in the United States. And the court said, well, that may or may not be true, but DACA had 2 prongs. And the other prong was not deporting people. And the secretary didn't discuss at all the reasons to get rid of not deporting people based on DACA status. And then regarding reliance, the court said the head of DHS never explained, or never talked about how she viewed the reliance interest. And she said, well, I didn't have to. That's not information I had to provide. And the court said, oh, yes, it was. So there are a bunch of dissenting opinions, unsurprisingly. Thomas and a couple of the other justices said, look, DACA is illegal, so how you rescind it doesn't really matter. It's illegal, just get rid of it. Justice Kavanaugh wrote a more nuanced opinion saying, we should have been able to look at the reasons that Nielsen added. So, okay, again, here you see Justice Roberts. Looks like he saved DACA, or did he? So DACA was saved, but on technicalities and probably only for a little while. So this case did not, or there's really, I guess the right way to look at this case is there's two issues, right? One is whether DACA is legal, and the other one is whether getting rid of DACA this way was okay. The court could have said that DACA was legal, but it specifically avoided answering that question. So there remains a question of whether DACA is in fact illegal. And a lower court in Texas has said, no, we don't think it is legal. And they will now be rehearing those issues because they had held the decision in abeyance while the Supreme Court was deciding. So there's other complicating factors as well. So even if DACA is legal, it can still be rescinded. And the Supreme Court sort of said as much. And so the question is, will President Trump try to rescind it? He has indicated that he plans to. But all sorts of procedural hoops have to be gone through to actually do this successfully. That's what didn't happen in this case that should have happened, so the Supreme Court said. So now the question is, will President Trump run out of time, or will he be able to do that? He has said he's going to do it, but we don't know. So the other complicating factor with this case is this. So when the court made this ruling, DACA went back to being in effect, if you will. But what's happened is that, and this has gotten kind of confusing, and there's different statements about it, is that, but apparently this is what's happening. The Department of Homeland Security is either rejecting or not processing new DACA applications. And a judge has questioned whether or not that should be happening. And I think has gone so far as to tell the Trump administration, well, for now, you have to continue processing these applications. So there's a lot more, I think on the day this decision came out, obviously there was a lot of excitement. A lot of people were very happy who were DACA recipients, who knew DACA recipients, who cared about this issue. There's popular support for this issue, throughout the United States. But it really was sort of a limited and temporary victory. And ultimately, Congress probably has to act to give DACA recipients any real protection over time. So the Bostock versus Clayton County case is another very exciting, very interesting, very dramatic Supreme Court case. Here the Supreme Court held 6-3 that gay and transgender employees may sue their employers for employment discrimination under Title VII, which basically outlawed sex discrimination, race, color, national origin discrimination, etc. So it was Justice Gorsuch who wrote the opinion, and he focused on textualism. That's how he said he came to the conclusion that Title VII, because of sex language, protects people based on sexual orientation and gender identity. He basically said that this language, because of sex, means that sex just has to be one factor. And he said if you take a situation and an employment situation, you change the sex of a person and you get a different outcome, that a Title VII violation has happened. And he gives an example of two employees, one who are both attracted to men, one's a man and one's a woman. It's okay for the woman, but not okay for the man. So if you reverse the sex in the scenario, you get a different outcome. And he said that violates Title VII. It's not maybe such a crazy idea when you consider the fact that the court has interpreted that because of sex language to also include sexual harassment, which it wouldn't necessarily naturally do so. But no one really sort of credibly argued that in 1964, when Congress adopted this law, that they were thinking about sexual orientation or gender identity. So the Chief Justice joined the liberals. And today there is a CNN article by Joan Biskupic that has some sort of inside dirt on what happened, and it indicates that the Chief Justice from the start was always planning on joining Justice Gorsuch's opinion. And of course, he's the one who assigned the opinion to Justice Gorsuch. So Justice Alito wrote a lengthy and rather bitter dissent. He talked about pirate ship textualism, the idea that you put up a peace flag on your pirate ship and call it textualism, but really you're a pirate. I don't know if that works, but that was his idea. Kavanaugh also said, he wrote a less sort of caustic opinion, kind of saying, look, the majority, as Tom Goldstein said, might be on the side of the angels here, but what about Congress? I mean, it's their job to rewrite Title VII. Justice Gorsuch's dissent as well Justice Alito's dissent went through just a litany of areas where he said, we could see changes in the law. The one that I never thought about that I thought was most interesting was housing and like college dorm rooms. How might that affect, how might transgender people being protected by Title VII, where similar language is included in a housing statute, affect how college roommates are assigned. People seem to think that the most impact will be the Religious Freedom Restoration Act, which is a federal law that gives sort of additional protection to religion. And so we'll have to see kind of how those things play out. So again, you might say that the Chief Justice saved gay and transgender employees. But again, he didn't do it alone here. He had Justice Gorsuch, who wrote the opinion, and really most of the attention in this case focused on Justice Gorsuch. Very little of it went to the Chief Justice. So like I said, Justice Gorsuch really ended up in the spotlight. I was not that surprised by his vote based on oral argument. He asked questions at oral argument indicating he could have gone either way, and that made a lot of us sort of think he was gonna go the way that he actually went. There was also like a leak in November indicating that he was going to vote this way. I was more surprised by Robert's vote, like I said, and I think it's important to note that Justice Gorsuch dons himself in the textualism mantle, if you will. And, of course, other justices like Justice Alito and Justice Thomas push back, and Justice Kavanaugh as well, saying, like, this isn't textualism. Like, this is something else. A lot of speculation as to why Justice Gorsuch went this way. I mean, the most obvious answer is that he really thinks that this is the best textual answer. The other thing is Justice Gorsuch has shown himself to have an individual liberty and kind of a libertarian worldview, and I would say that that's consistent with his vote in this case. It's well known that he attended a lefty Episcopalian church in, I think, Boulder. And as someone who lives by the biggest Episcopalian seminary in the United States, I can say, like, I walk my dog there every day. I'm bombarded by pride flags and Black Lives Matter. So, I mean, it's possible that that influenced him. People have speculated he wanted to distance himself from President Trump, and this provided an opportunity for him to do so. And sort of similarly on that note, the idea that Justice Gorsuch may have been trying to buy some political capital in the sense of kind of, giving the liberals a victory so he doesn't look sort of as conservative as he is. Espinoza versus Montana Department of Revenue is an absolutely fascinating case for so many reasons. And it illustrates a trend that I'm going to talk about when I get to the end of the case. The holding in the case is basically this, that the United States Free Exercise Clause allows families to receive a tax credit-funded scholarship to attend a religious school regardless of Montana's constitution that says no aid may be given to sectarian schools. 5-4 decision, again, the Chief Justice wrote the opinion, and he was joined by the conservatives this time, not the liberals. And Justice Kagan was the only liberal justice not to write her own dissent. The simplest way to understand this case is this. You have to imagine sort of a conflict between the United States Free Exercise Clause and the Montana's Constitution's no aid to sectarian school clauses. So which clause is going to win? And the Supreme Court says basically that the U.S. Constitution's Free Exercise Clause wins, and about 30 states have these so-called Blaine amendments or super anti-establishment clauses, if you will. So no one talks about this aspect of the case, but it's really interesting for you guys because you're state legislators. There is a massive intergovernmental struggle in this case. So the Louisiana legislature came up with this tax credit program where, you could give money to this student scholarship organization, and then parents could kind of collect these scholarships and take them to religious schools or otherwise. So the Montana Department of Revenue developed a rule saying, oh, by the way, you can't use this scholarship at a religious school, even though the legislature said you could. So what the Montana Supreme Court did is they struck down the entire scholarship program, not just the part going to religion, the entire scholarship program, saying it violated the Montana Constitution. So really interesting sort of setup. This case is nominally presented as sort of a battle of precedent, but really it's a lot bigger than that. The court had said a couple of years ago in a case where there was a program to give organizations money to resurface playgrounds, and religious organizations couldn't receive these grants. And again, Missouri had sort of a super establishment clause. And the court said, well, we're not going to decide for anything other than playgrounds, but we're just going to say if the state is giving playground money away, it has to also give it to religious schools. But we're not going to say anything outside the context of playgrounds that are affiliated with churches. So the court basically extended that case to this case and said, look, what's really happening here is that the only reason these schools can't get money is because they're associated with religion. And that's just not sort of okay under our precedent. Now, there was a competing precedent. This is Locke versus Davey out of Washington State, where the state constitution said state money could not be used to study devotional theology. And the court said, this case is kind of different because, there's been a long tradition of states actually using money to support educating people at religious schools, but there isn't a history of states using money to actually educate ministers, per se. So the dissent tried to say, well, the whole program went away, so how can there be a constitutional problem? And the Montana Supreme Court got rid of the entire program. And the court said, yeah, they only got rid of the entire program because they didn't understand the underlying law properly, which is that the federal constitution trumps the state constitution. So one way of looking at this case is Justice Roberts saves a tax credit program that helps low-income families go to schools of their choice. A lot of evidence that it was low-income families that largely received the scholarships. The other way of looking at this case is that now, if the government offers a benefit, it basically has to be open to religious organizations as well. I mean, that's kind of what this case holds. And what Tom Goldstein said about this and what other commentators are saying as well is that, look, the one area where the Supreme Court is being most aggressive on the conservative side and gaining the most ground is actually in the religious space. So one way to sort of look at the world is like sort of pre-1980 or maybe pre-1990, the Supreme Court had said, if you're giving money to religious organizations, that's just not okay. And then in the 90s and maybe the early 2000s, the court was saying, well, if you're giving money to religious organizations, that might be okay. And now the court is saying, okay, if you're giving money just sort of generally, you have to make that money available to religious organizations as well. So this case, even though it seems like, just about this narrow little scholarship program, is actually like a lot bigger than that. And I think the consequences of it are going to be that, it's going to be for vouchers, it's going to be for all sorts of other things. So I even heard a commentator say, look at CARES money and other sort of federal money. Like if it's available to some organizations, why won't it now be available to religious organizations? So this is a really big step for the court to take in a more conservative direction. So a few words on the gun case, which met a sort of, I don't know if I should say untimely demise, but it met a demise at the Supreme Court. So as you probably all know, in 2008, the Supreme Court said in the Heller case that individuals have a right to a gun in their home to use for self-defense. And there are a lot of questions unanswered from that. Do you have a right to possess a gun outside the home? What kind of gun? Those are the questions that remain unanswered. So basically, New York said you can have a premises license, and that premise license basically allows you to keep a gun in your home. People with premises licenses challenged it and said, well, we want to take it to a shooting range in New Jersey. or we want to take it to our second home in the Hamptons. And New York, the court accepted the case, and New York basically knew it was going to lose. So it amended its premises license to say, oh, by the way, you can go to a shooting range outside the city, and you can take it to a second home. And so the court said, okay, the case is moot. New York has changed their law. But the court was sitting on like 10 petitions that raise a question about use of guns. And everyone was expecting the Supreme Court to accept another one of these cases. And I will mention that there's a circuit split over the right to carry a gun outside the home. 4 justices had been on record saying, we want to accept one of these cases. And it only takes 4 votes to grant a petition. What happens? Cert denied in all those cases. So everyone can kind of speculate. It's Justice Roberts who doesn't want to get involved in the gun cases. And the theory is he doesn't want to tackle them now. I think most people, myself included, believe that he believes in a broad interpretation of the Second Amendment. He just isn't willing to commit to it on paper for whatever reason. I think the court was willing to take the New York case. Roberts was willing to take it because it was so narrow. All the challengers wanted were to do 2 things: take the gun to the Hamptons and take the gun to New Jersey. And I think Roberts was willing to say, okay, you're allowed to do that. But that's been kind of an exciting and dramatic turn. So now, like the $1 million question, what happened to the Chief Justice? How can we explain his votes this term? So here's our Supreme Court in all its glory. Now you can look at all their names in the conservative camp or in the liberal camp and have that asterisk next to Justice Roberts. People seem unwilling to call him the new swing justice. They want to call him the centrist justice. But either way, he is the median justice. Either way, these days, he is the justice in the middle. How did he get there? Well, Justice Kennedy, for 12 years, occupied that middle position. Then Justice Kennedy retired, and he was replaced by Justice Kavanaugh, who is expected and is proving to be a fairly reliable conservative. But Justice Roberts has shown some moderate streaks, particularly later on in his career, and particularly in holding that the ACA was constitutional as a tax. So let's talk about what happened with Justice Roberts and his more liberal votes. The bottom line is, I don't know why he voted with the liberals in a lot of these big cases. No one knows why, and we may never know why. But for sure, he did take some significant turns. I cannot imagine the Chief Justice of 15 years ago siding with the employees in the transgender gay Title VII case. I just can't imagine it. But on the other hand, he did a lot of things on his own terms, and he did them also kind of narrowly and kind of sneakily. I think that the DACA case and the abortion case are both very narrow. The headlines were, like I said, Justice Roberts saves the world, but a closer look was like, DACA's not that safe, and he just got rid of part of whole women's health, even though he said he was sticking with stare decisis. Anyway, but he has a pattern of doing things on his own terms and being a little sneaky, and I think the census case is a great illustration of this, as is the ACA case. Another thing about the Chief Justice that is really incredible is in 60 out of the 62 cases the court decided this term, he was in the majority. 60 out of 62. Until Lyle Dennison said this, I had never really thought about how important it is to the chief to be in the majority in the big cases. And I think this term is an illustration of this. So our commentators overstating it when they say, wow, Justice Roberts really went left. He's going to be the new Justice Souter. I think without a doubt we're overstating it. I think my friend Adam Liptak at the New York Times has it exactly right, and I'm going to read this. He steered the Supreme Court toward the middle, doling out victories to the left and right in the most consequential term in recent memory. I actually think that's a more accurate description of what happened. But I also like how Tom Goldstein describes the Chief Justice as a conservative, but just not an aggressive one. And commentators point to 2 areas where the chief has really sort of stayed conservative. And one of those is the business cases. We never talk about these in this presentation. And the other thing is voting. You don't have to look this year to see the Chief Justice's track record on voting, but it's been very conservative. And also there has been a bunch of sort of shadow docket challenges to voting changes that judges have made. And Justice Roberts is not interested in going along with changes that judges have made to accommodate voting during the pandemic. As I said before in this presentation, the biggest surprise for me was the gay transgender case. And I'll say this. When I first started talking about this case, and I started talking about it before the court had even accepted it, I thought Justice Roberts might go this way. And it's for the reason that Tom Goldstein says, but I never articulated it to myself that way. And that reason is this. The court was kind of going in one direction on homosexuality. And for the court to sort of like sharply change just because Justice Kennedy left might have looked a little weird. And I think the Chief Justice probably just didn't want to go that way. I also think, too, but it's important to remember that Chief Justice dissented bitterly in the same-sex marriage case, and it's the only decision he's read from the bench. But it's important to think about this, too. This case is a statutory case. Congress can overturn the Supreme Court tomorrow if they want to, whereas a constitutional case is kind of a different matter. And there's other theories, too, as to why the Chief Justice did this. I think the other thing, too, that he might have been thinking about was that he could really have fly under the radar because of what Justice Gorsuch did, and that proved to be absolutely true. But his vote really surprised me. It surprised me more than any of the other votes. So the prevailing theory on why the Chief Justice sort of did what he did is the going left for the institution. So as I've said before, we have 5 justices on the courts who were appointed by Republican presidents and 4 justices who were appointed by Democratic presidents. And if those 5 justices appointed by Republicans always go one way in big cases and the 4 Democrats always go another way, the court looks really political. So if the Chief Justice sort of mixes things up, then the court doesn't look as political. Now, conservatives push back at this theory and they say, how is it that the court can look less political by making political considerations in how they vote? The other speculation is this, that Justice Roberts might have gone left this term to sort of help the right in this election. And the theory there is that by going left, he sort of took the Supreme Court off the table. By sort of making it look nonpartisan, not very interesting. Oh, you never know what the Supreme Court's going to do. Why even bother with them? I'm uninclined to be of that view, but there are many people who believe that. Another Roberts truism that I think just as well explains this, or almost as well explains this, as him caring about the institution, is that what Chief Justice Roberts loves is narrow rulings and going slowly. He may ultimately one day vote to overturn Casey or Roe versus Wade, but it's probably going to take a long time for him to get there. And I love Jonathan Adler's term, anti-disruption jurisprudence. And that, I think, is a very, very fair way of describing the Chief Justice. So I think it's always important for Americans, not just state legislators, but Americans to think about this. The Chief Justice, Kennedy, O'Connor, in my lifetime, really, there's always been one that's had there's always been one justice that's had a lot of power. And now it's the Chief Justice. It hadn't been the Chief Justice for a long time, but now it's the Chief Justice. And the reason why it makes more difference that the Chief Justice is the one that has a lot of power is that he assigns the opinions, which can sometimes determine whether votes get switched and stuff like that. I think when commentators, though, compare this Chief Justice to other Chief Justices, they're making the wrong comparison. I think if you want to contemplate the power that Chief Justice Roberts has, you should compare him to any other person. You should compare him to the President of the United States. You should compare him to Mitch McConnell. You should compare him to any other powerful person. And I think he stands up in terms of power right next to them with having just an incredible amount of power. I would even say the amount of power he has is scary. But the reality is that Chief Justice conjures up more annoyance than fear. So one of the friends I've made through NCSL was a former Hawaiian legislative staffer, and he said this about the Chief Justice: too conservative for the liberals, too liberal for the conservatives, yet wielding his authority as chief to protect the court while incrementally moving his own agenda forward. That's him in one sentence. And his politics and the problems and the drama associated with him. So I think these are the big questions that we have going forward. How long will he retain the power that he has? So as we all know, Justice Ginsburg has been diagnosed with cancer 5 times maybe now. She has liver cancer. It's come back, or it's new, and she's had it for a while. It's possible that she could die. It's possible any of them could die in the next couple of months. If Chief Justice now or in the future is no longer in the middle of the court, will he stay centrist? If there's another conservative on the court, will he stay as a centrist justice? And I also think, too, none of the cases this term really squarely address race. And, that it would be hard, I think, for Justice Roberts to really go left on a case where making different decisions based on race was a factor. Kennedy did it, but he only did it once or twice. And he only did it very, very much at the end of his career. So if Justice Roberts stays in the middle, what will he do on the race question? I don't know. So I'm going to finish this presentation by very quickly, because I am determined to leave time for questions, very quickly talking about the president's tax return cases. There are actually 2 cases involving, sorry, I got a little ahead of myself here, one involving Congress and one involving a New York City prosecutor. The president won and lost both cases, which I'll be talking about at the end. But for sure, the state prosecutor, it's really a local prosecutor case, was a win for state and local government authority. The cases were 7-2, meaning they were not close, and they were written by the Chief Justice. So the Vance case involved the question of whether or not a state prosecutor or a local prosecutor really could use state subpoena authority to subpoena the president. And the Supreme Court said yes, like I said, in a 7-2 decision. The president sort of said, I should not, it's true that the president said it's true that the court has held that presidents can be subject to federal subpoenas. But why should they be subject to state subpoenas? That doesn't seem fair. It seems like it might be harassing, overwhelming, used to sort of get the president to not focus on his or her job. And the court basically said, the president, when it comes to his private papers in particular, is just like any other person. There's no absolute immunity. There's no heightened scrutiny. But there's another question in this case, which is the question in the case is really, can a subpoena be can it be issued? It's a different question about whether the president actually has to comply with a subpoena. And so that's what we're talking about right now. You probably saw in the news yesterday that President Trump filed some papers saying, okay, fine, like I get it, you can issue me a subpoena, but this subpoena that you issued, it was a fishing expedition, it was too broad, you asked for me for everything under the sun. I can't be forced to comply with something this big. So I think most commentators think that ultimately the president will have to comply with the subpoena. Maybe some of the requests will be cut down, but he will ultimately be forced to comply. But he's going to be giving it to a grand jury, not to the American people. So Trump versus Mazars, this is a question about whether or not Congress had the ability to subpoena President Trump's financial documents. And a couple House committees thought this, and the Supreme Court's test has been this. Congress can get any information they want because they need information to pass laws, right? So they should be like trying to find information, as long as the information has a valid legislative purpose. If that sounds broad to you, it sounds broad at the Supreme Court. Supreme Court said basically like any information could arguably be relevant to legislation. And considering the fact that the president and Congress have a contentious relationship, we think there should be a special test for valid legislative purpose when it comes to Congress or when it comes to the president. And then the court went on to articulate what that test will be. So now let's talk about the wins and the losses. So like I said, this case was definitely a win for the president in this sense. His tax returns will not be released to the public before the November election. I mean, I just don't see any scenario where that sort of happens. It was also a loss for the president because, like this New York prosecutor, like I said, now has definitively this clear authority to issue a subpoena under state law. This case is also, I think, a big loss for Congress because remember, like in Congress's relationship to you or I, Congress could subpoena our information as long as they had a valid legislative purpose. They could get my back bank records to sort of look at corruption or whatever. But now the president has his own test, which will make it harder. And Victoria Norris, who's a professor at Georgetown Law School, said, "Isn't it kind of crazy that some random New York City prosecutor has greater authority to access the president's records than Congress does?" I don't think she's necessarily wrong about that. So anyway, that is the summary of the biggest of the big cases affecting state government, particularly focused on the cases where the Chief Justice maybe went in a different direction than some of us, myself included, was expecting to go. And I'm very proud of myself. I wanted to be done by 3:50 Eastern at the latest. It is 3:49. So I am now happy to take questions.
Well, thank you very much, Lisa, for your presentation. We miss you in person, but this is the best we can do. This is State Representative Roger Goodman from the state of Washington, co-chair of the National Conference of State Legislatures Standing Committee on Law, Criminal Justice, and Public Safety that's sponsoring this webinar. Just to let you know, this webinar is being recorded for those who couldn't catch up with the whole presentation and will be available on the NCSL website as well as the website of the State and Local Legal Center. We have a couple of questions that have come in. The first one is from Eric Schuller about the Oklahoma case. The Supreme Court very recently ruled that the entire eastern part of Oklahoma is Indian land. Interesting to see what the consequences of that will be.
So thanks for that, for asking me about that case. It's interesting. When I talked about this case last year, when I gave this presentation last year and a whole bunch like it, and I would ask for questions, people always wanted to talk about this Oklahoma case. And I couldn't figure out why, because it was a very obscure case, and the court at that time hadn't ruled yet that half of Oklahoma was on an Indian reservation. So I didn't know why anyone was interested about it. And I finally, after presentation, beelined to the woman who asked me, and I was like, "Why did you ask me that?" And she told me that there was a podcast about the case. I listened to the entire thing. It was a little unbalanced, but it was absolutely fascinating, and I commend it to all of you. The long and the short of it is what happened in the case was that when Congress established a reservation, they could only get rid of it by disestablishing it, if that makes any sense. And to disestablish a reservation, according to Justice Gorsuch, they had to use words that said something to the effect of, "We are getting rid of this reservation." What happened in Oklahoma was basically these tribes were kicked out of, Georgia and Arkansas, and they were given land in a reservation in Oklahoma and told, look, they'd have it forever. And then Congress did a bunch of stuff to sort of undermine the tribes, took their governance authority away, just did a bunch of things. But according to Justice Gorsuch, they never came out and said, they said, we're going to treat you really badly, but they never said, and we're taking your reservation status away. Why this reservation status is important is that if an Indian kills another Indian and maybe a non-Indian on a reservation, they can't be prosecuted by the state. They have to be prosecuted by the federal government. And the guy in the case said, look, I killed someone, I'm an Indian, I'm Native American, I killed someone on a reservation, you couldn't have prosecuted me. So that's why it matters whether or not it's a reservation. The drama of the case is that there's a couple things. One, it took the court 2 terms to decide it. They couldn't decide it last term because Gorsuch had sat on another case with another criminal defendant when he was on the 10th Circuit. They basically switched out defendants and then Gorsuch could hear it. But the big drama was this. Not this term, but last term, Gorsuch had twice voted in favor of Indian tribes, or maybe even 3 times. And people were like, whoa, is he just pro-tribe or what? And then when this Oklahoma case came up, it was like, oh my gosh, everyone thought he's going to vote for the tribe, and he did. So it's going to be interesting to see how it all turns out. You know, the tribes in Oklahoma, state and local governments are trying to kind of work out the decision. I have a friend who sends me press releases on the continued conversation. I mean, I've heard people say, look, you know, in Washington State, for example, where Representative Goodman is from, there are cities that are located on reservations. It's not a big deal. On the other hand, like, no one thought they were living on a reservation for like the last 120 years. I mean, isn't that weird? So it was absolutely a gripping case. And if you're interested in it, highly recommend listening to that podcast. I can't think of the name of it. I should have looked it up because I knew someone was going to ask me. But it's absolutely a fascinating Supreme Court case, and it shows the power of one justice. It's got a little stick in his craw for tribes.
That was my question, because Justice Roberts and Alito, Kavanaugh, and Thomas sided with the state of Oklahoma. And so, you know, on the conservative, actually, Senator Ted Cruz from Texas said something like, Neil Gorsuch and the 4 liberal justices just gave away half of Oklahoma, literally. Manhattan is next. So what is it about Justice Gorsuch? What is it about Justice Gorsuch where he would side with the tribe? Is there some historical, pattern of his ruling on these matters, or?
So I think there's a couple of things. I think it's sort of that individualism and the libertarian a little bit. I think he has somewhat of a place in his heart for the downtrodden. That's been suggested as well. Although, like, when his confirmation hearings happened, you know, he had not sided in favor of the frozen trucker, and people are like, this is a man that has no heart. But I don't think that's true. I think he does. He writes with some empathy towards people that have less. The other thing, too, is the simple idea of, like, the government has to keep its promises. That's another way of looking at these cases. It's not so much about tribes. It's just about whether the government keeps its promises. And if there's one place where government hasn't kept its promises, it's tribes. So I don't think he had a great depth of Native American cases when he was on the 10th Circuit. I don't think people saw this coming. And I don't think there's a clear answer for why. But I will say, if this is any help at all, like another sort of parallel, but for Justice Alito, this sort of cuts a different way. Here, his vote kind of cut against being conservative. Justice Alito is obsessed with victims, and he hates criminal defendants and won't ever vote against them. And so, like, sometimes, like, justices just have this thing, and usually it takes a long time. I think it took years to see that, like, Justice Alito just had it in for criminal defendants. But with Justice Gorsuch, it was like, boom, the first term he was on the court, there were 3 cases. He voted in one direction, and he's never looked back. So it's just kind of interesting. So
we've got some feedback from other participants. The name of this podcast is called This Land, crooked.com. So if those of you who are interested in learning more, go to crooked.com and get the podcast called This Land. So we have another question from Laura Sankey-Keep. In Espinoza, can you address the distinction between religious status and religious use? Are there any suggestion on where to look for figuring out how to navigate this distinction?
So, Laura, great question. So what the court said, it was, okay, in Trinity, right, this is a playground case. This playground was treated differently because it was affiliated with the church. It had nothing to do with how the money was going to be used, playground or not playground. It was because it was a church. So the court said, okay, same thing in Espinoza. That the reason the money couldn't go to these religious schools is because they're religious. So so this case is not about, according to the court, it's not about religious use, it's about religious status. In my opinion, that is a distinction without a difference. And it was sort of like the court saying in Trinity, oh, this is just about playgrounds. No, it's not, and we all know it's not. And even the Chief Justice said, well, you know, a lot of us don't even believe there's any real difference between religious status and religious use. I think that, like, I haven't heard any commentator say, view this case narrowly, there might be a difference between use and status. Everyone, I think, is kind of the opinion that, like, it's just a matter of time till the conservatives clear that up, that religious status and religious use are effectively the same thing. But that's just my opinion, and it's not decided in the case. I mean, the Chief Justice says it's not decided, but then but it's like wink, wink, nod, nod. It's not decided.
Oh, interesting. I have a question about police accountability in the wake of this national uprising on police community relations after the George Floyd incident and others. The doctrine of qualified immunity is on the docket. Qualified immunity when a law enforcement officer may not be held civilly liable if he's abiding by the law and with his law enforcement department's procedures. Do you see anything upcoming on this qualified immunity? Will there be narrow or broad decisions on this?
So that's such a great question. So here's the deal. Long before anything happened with George Floyd, and I think more part and parcel with what happened with Michael Brown, a bunch of academics got together and wrote a slew of papers saying qualified immunity is wrong, and the Supreme Court created it and should get rid of it. And a bunch of organizations, like advocacy organizations, had also started filing briefs to the Supreme Court saying, "Court, you need to get rid of qualified immunity. It's a faulty doctrine and it needs to go." So, I mean, literally a week before George Floyd was killed, the court for the first time looked at petitions in about 10, 15 cases where the court was asked to overturn qualified immunity. And at the end of June, they denied all the petitions. They didn't accept any of the cases. But I think someone issued a dissent. So the theory is that the court may have decided before George Floyd not to get involved in the cases. But they didn't dismiss all of them because they had to hold on to one of them while one of their colleagues, I think it was Thomas, wrote a dissenting opinion. All this to say that the court just turned down a major opportunity to get rid of qualified immunity or change it. I think there is definitely an appetite on the court with at least a couple of justices to get rid of qualified immunity. There might even be enough appetite on the court to find 5 justices who might be willing to change it. I think this is the problem. No one really knows how to change it. Like if you look at the congressional, the proposed laws, they're mostly like just get rid of it. It's a hard doctrine to figure out a good way to modify. And so a question is, will the advocacy groups keep on asking? And another thing that they're trying to do, a big thing they're trying to do is to get lower courts to criticize the doctrine and to sort of in close cases rule against police officers and to kind of use that as ammunition for saying, hey, this is like lower courts don't like this, to kind of sort of change things. I don't think we're going to see anything in the near future on qualified immunity because the court just literally had a chance to go there and didn't. But as personnel changes and as more academic writing is done, as more thinking is done, it might happen. But it was a very tense time for those of us who defend qualified immunity that after George Floyd's death, waiting to see what the court was going to do, I thought qualified immunity was in big trouble. It's safe for now.
Yeah. In Colorado, they just enacted legislation not to get rid of qualified immunity, but to raise the pain, I guess, the penalty, the monetary penalty if you are found civilly liable. So there's some adjustments going on in the states. Here in Washington State, we're also considering whether to adjust the qualified immunity doctrine. Well, I'm looking at the clock, and we've, as my therapist tells me, looks like we're at the end of our time. But we do want to thank Lisa Soronen so much, and it's just a shame that we haven't been able to be all in person again in the same room. Hoping next summer we'll be able to do this in Chicago. For those who are observing this, you'll see a tab that says Resources on your screen. You can download a PDF version of Lisa's PowerPoint presentation and others as well. So, again, thank you very much for participating in this webinar. It's always very instructive to learn about the Supreme Court cases coming down and their interpretations. So, thanks very much, and we will see you in the next webinar.
Talk to you next week.